Good morning or good afternoon, depending on when you access this webinar. But in any event, we appreciate you accessing it. This webinar is being conducted for the Bench Bar Conference and sponsored by the Memphis Bar Association. I am Terrence Reed, and my colleague David Billions and I will discuss in some detail various aspects, legal aspects regarding the enforceability of restrictive covenants in the employment context. And we will pay special attention to covenants not to compete agreements. I am the Managing Director of Employment Litigation for Federal Express Corporation, and David is the Managing Director of Commercial Litigation for Federal Express Corporation. So David, I will turn it over to you to start the discussion on restrictive covenants.
All right, first I'd like to start off with the basics and cover the four most common covenants employers have high-level executives or employees with specialized knowledge execute, which are, of course, non-competes, non-solicitation agreements, confidentiality and non-disclosure provisions, and non-disparagement agreements. Now, each of these covenants is typically included as a separate provision in an overall employment agreement an incoming employee executes when hired. However, of course, current employees also may be presented with a restrictive covenant as long as adequate consideration is provided in support. And just covering the basics, the enforcement of each covenant is governed by state law, which Terrence will discuss in more detail as we go along. In its most basic sense, a non-compete agreement prevents an employee from working for a competitor either at all or in the same field of work for a specified period of time after leaving his employment. They're executed to prevent the employee from sharing specialized knowledge he obtained from the employer with a direct competitor, which would include things like trade secrets, or other confidential or proprietary information such as pricing information, intellectual property, or business plans. Non-competes are also necessary to preserve existing customer relationships, defend the company's goodwill, or maximize the company's investment that it has put into providing specialized training to that particular employee. They must be reasonable in scope as to time and geographic area, and they are narrowly construed by state courts because they are a restraint on trade. A couple points I'd like to raise are: one, an employer should only present a non-compete agreement to targeted employees who truly possess confidential or proprietary information that a competitor could use to obtain an unfair advantage over the employer. They should not be given out across the board to entire groups or departments of employees, unless, of course, that particular group would have access to highly confidential information that needed to be protected in case the employee left. The non-compete should also be limited to the specific type of work or field the employee is working in. Non-solicitation agreements seek two things, really. A departing employee from soliciting existing customers after leaving the company would be prevented by the non-solicitation agreement. And also the agreement would prevent the employee from poaching or bringing with him to his new business venture employees of the company. I'd say non-solicitation agreements are easier to enforce than non-competes because they are not considered restraints on trade. However, they must be reasonable and must not be any broader than necessary to protect the employer's legitimate business interest. So an example of an unreasonable restraint would be if the agreement defines solicitation as any form of advertisement. In that case, a court would consider it overbroad and unreasonable because the former employee could not find work in the same field if he could not advertise at all, or his new employer would have to cease all advertising to hire him. So the terms must be narrowly tailored and clearly defined. Another point with respect to non-solicitation provisions would be that an employer does not have a legitimate interest or business interest in preventing a former employee from providing services to personal clients who came to the company through the person's independent recruitment efforts. And one last issue, the question of whether a communication by the departing employee constitutes a solicitation is often litigated. So for example, if the departing employee sends out an email notifying the company's clients of his departure, but does not directly solicit the clients in the form of the email to come work for him in his new business, the question of whether this is an implicit solicitation in violation of the agreement would be litigated. And of course, the analysis of this situation really would be fact. Now, non-disclosure confidentiality agreements, these of course prevent the departing employee from disclosing confidential or proprietary. Examples of which would include a business model to be presented to a venture group for possible funding, intellectual property, plans for a new tool or technology that are being developed by the company, or if you had lab workers who had access to test results before the results were given to the patients. Those would be the types of information to be protected. A non-disclosure agreement must contain three things. One, definitions describing the confidential information to be protected, and also exclusions that would describe the information that is not protected. Number two, the obligations of the parties, and three, the agreement must set forth a reasonable time period that the employee is prohibited from disclosing the information, although some courts have found that the prohibition may be indefinite depending on the nature of the information and its sensitivity. Of course, even though the agreement must provide definitions of what the confidential information is, courts retain the discretion to determine exactly what is confidential and what constitutes a trade secret under the law. Another point I'd raise with respect to non-disclosure agreements is typically a liquidated damages provision is linked to a breach of the agreement because damages are difficult to quantify. Two other points. In 2016, the SEC announced that it considers illegal any employer-imposed limitation on an employee's ability to disclose confidential trade secret information to the SEC in pursuit of a whistleblower claim that the employee has filed. The SEC has also announced that the employer has an affirmative obligation to advise employees of their right to be able to disclose confidential information to support a whistleblower claim. Another point is that if the employer files an action for breach of a non-disclosure agreement and does not have a non-compete agreement in place with the employer can get a non-compete agreement granted by the court as injunctive relief, assuming the employer can meet the elements of enforceability under state law. And now with respect to non-disparagement agreements, of course, these are much more common now because we live in a social media world that gives former employees really unlimited platforms to post negative information about their former employers. In its most basic sense, non-disparagement agreements prevent employees from taking action that negatively impacts a company, its reputation, products, members of management, or services. I saw somewhere that these agreements are now included in about a fourth of all executive employment agreements. Disparagement is broadly defined. It's a broadly defined term that could include, anything from telling a friend that the boss is a jerk, to posting negative opinions about the company on Twitter, to giving an interview that shines a negative light on the company. It's proving a statement is disparaging is not particularly difficult. It's a much lower standard than defamation. The employer must prove that the statement is untrue and the disparagement is incorrect. However, damages may be difficult to prove, so employers typically include a liquidated damages provision, which is linked to a breach of the non-disparagement agreement. One other note, non-disparagement agreements are also often included in a severance agreement or a settlement agreement with an employee if the employee has filed a claim against the employer. The employee often argues that non-disparagement should be mutual in that situation, which is very difficult for the employer to agree to, depending on the employer's workforce, because of course the employer cannot control the actions and statements of all of its employees. So with that, I'm going to turn it over to Terrence to talk about enforceability of non-competes.
And now I will discuss the primary factors that courts consider when determining whether a non-compete agreement is reasonable and thus enforceable. So when determining whether a non-compete agreement is reasonable, courts consider whether the employer has a legitimate interest it is protecting with the agreement. And these legitimate interests, David covered several of those. I will go into some detail regarding those. But one of the focal points is that simply preventing competition is not a legitimate interest and may actually be an antitrust violation. Some legitimate interests include, as David mentioned earlier, protecting trade secrets, which could substantially affect the employer if used by a competitor. It could be maintaining valuable confidential business or professional information. It could also be preserving relationships with specific prospective or existing customers. Also, legitimate interests could include defending goodwill associated with an ongoing business by way of a trademark or a geographic marketing or trade area. It could also be maximizing the employer's investment in extraordinary or specialized training that it provided to the employee. Courts will also consider the nature of the work that the employee performed and the length of time the employee was employed by the employer. Courts will also consider whether the employer shared trade secrets with the employee, which could, again, substantially affect the employer if used by a competitor. And courts will also consider whether the information the employee possesses is really kept confidential by the employer, and whether the knowledge the employee has is unique to the employer, or in contrast, whether it is of a general nature, such as general sales experience. Courts will also consider the benefit to the employer versus the detriment to the employee. And so in essence, courts will undergo a risk-benefit analysis. And if the benefit to the employer is disproportionate to the detriment to the employee, then courts are not likely to enforce the non-compete agreement. One of the big areas in the enforceability of non-competes deals with the geographic scope of the restriction. This is of vital concern regarding the enforceability. The reasonableness of the geographic scope of the restriction may be determined by considering factors such as the standard restrictive covenants in the applicable industry, the rate of changes and developments in the technology of that industry, and the geographic reach of the employer. Geographic restrictions must be narrowly tailored to meet an employer's legitimate business interests, as David mentioned earlier. But under some circumstances, several courts in various jurisdictions have found a worldwide geographic restriction to be reasonable based upon the broad scope of the employee's responsibilities, the international nature and scope of the employer's business, and the industry in general. Courts that have found a worldwide geographic restriction to be reasonable usually relied in part on a limited 1 year duration of the restriction. And so now let's shift gears to duration, which is another focal point regarding the enforceability of non-compete agreements. So the reasonableness of the time of the restriction may also be determined by considering factors such as the standard restrictive covenants in the applicable industry, and again, the rate of changes and developments in the technology of that industry. Courts typically find a 1 year restriction to be reasonable. In fact, several recently enacted state statutes, like the Massachusetts law that went into effect in August of 2018, several of these laws, state statutes, require that non-compete agreements be limited to 1 year. In some circumstances, however, courts have reduced the duration of non-compete agreements based on the employer's selective enforcement of lesser durations as to other comparable former employees and the employer's offer of a lesser duration in negotiations over the non-compete agreement. So this is a scenario where selective enforcement can harm the employer. So an employer always wants to think about consistency when it comes to enforcing non-compete agreements. As with non-compete provisions, non-solicitation provisions may be held unenforceable if they are unreasonable in time and geographic scope. But restrictions on disclosure of confidential information and trade secrets are generally not limited in time or geographic scope and may last forever, as David mentioned earlier. Shifting gears to restricting the employee to previous specific type of work, courts will typically not enforce a non-compete agreement if it is not narrowly tailored to the employer's job duties at the former employer. So to be enforceable, the non-compete agreement should only restrict the employee from performing the specific type of work he was doing with the former employer. Garden leave provisions. Garden leave provisions allow employees to continue to receive some amount of compensation, and many times it's their normal pay, but to receive this compensation during the duration of the non-compete restriction. So if the duration of the non-compete agreement is 1 year, a garden leave provision would require the employer to compensate the employee during that 1 year when he or she is restrained from working for the employer's competitor. And obviously, as one might imagine, courts are more likely to enforce non-compete agreements that have these garden leave clauses in them. And in fact, several state laws require garden leave clauses in non-compete agreements unless there is, quote, other mutually agreed upon consideration, end quote. Now, let's talk about the circumstances surrounding the employee's separation from the employer, because courts certainly consider this aspect when they are determining the enforceability of a non-compete agreement. So when determining whether a non-compete agreement is enforceable, courts look at this. And some federal courts have held that when an employee is involuntarily terminated without cause, non-compete provisions are per se not enforceable. If an employee is terminated due to, for instance, constructive discharge, a layoff, a reduction in force, or merely the elimination of his or her position that's unrelated to the employee's performance or conduct, or as we have seen in recent months, an economic downturn. If these scenarios are at play, the employer will likely, in many jurisdictions, not be able to enforce the non-compete agreement. And courts in Arkansas, Iowa, Kentucky, Maine, Mississippi, New York, Pennsylvania, South Dakota, Tennessee, and DC all take that position. And courts in these 10 jurisdictions have refused to enforce restrictive covenants against employees whose employment is terminated for reasons other than the employee's performance or conduct. Thus, whether an employee is subject to a non-compete agreement is something that employers should consider when deciding to terminate an employee. If the reason for the employee's termination is employer misconduct like discrimination, harassment, fraud, whistleblower retaliation, breach of contract, illegal activity by the employer, or any similar misconduct, then most courts have held that a non-compete agreement is no longer enforceable. And the rationale for that is because illegal conduct by the employer was not a part of the employee's expectation at the time he agreed to the non-compete. So if the reason for the employee's termination is employee fault, like poor attendance or poor performance or similar problems like that, then the fact that the employee was terminated probably will not be as significant. Nonetheless, courts may be less eager to enforce a non-compete agreement where it was the employer's decision to terminate the relationship, not the employee's decision. And many state statutes expressly prohibit the enforcement of non-compete agreements against employees terminated without cause. However, most of these laws do not define the term, quote, without cause, end quote. So leaving it up to wide interpretation. So I suggest that employers include a specific definition of what constitutes cause and without cause in the non-compete agreement. Because if the non-compete agreement is silent on this definition, then courts will probably refer to the common law definition. Courts will also consider what we call the employee choice doctrine, which I will discuss in a little more detail later in this webinar. But the employee choice doctrine is when employees voluntarily separate from an employer. And the doctrine provides that employees who voluntarily terminate their employment may choose to either comply with the non-compete agreement and receive certain compensation like severance or deferred compensation or equity awards, or the employee has the choice of engaging in the restricted activity and foregoing the compensation or the award. However, when an employee is involuntarily terminated without cause, the employee choice doctrine does not apply, and the court must determine whether forfeiture is reasonable at that point. Now, lastly, I want to focus on the public interest concern. The public interest factor is usually not relevant to most employers. It largely encompasses non-compete agreements in professions that involve a public interest, such as the practice of medicine or our practice of law. These professions, among certain other ones, will entail a personal relationship between the professional and the patient or the client. These relationships are highly fiduciary and peculiarly dependent on the patient or client's trust and confidence in the physician consulted or the attorney retained. In both contexts, restrictive covenants have a destructive impact on those relationships and are thus considered contrary to the public interest and invalid. In Tennessee, disciplinary rule 8 and Tennessee case law, Tennessee prohibits non-compete agreements that lawyers enter into. And speaking of Tennessee, we wanted to cite to 3 of the seminal Tennessee cases that address the enforceability of non-compete agreements. And the Spiegel versus Thomas Mann and Smith case is actually the Tennessee Supreme Court case that discusses non-compete agreements that lawyers enter into. All right, let's delve a little bit deeper into consideration that supports non-compete agreements. In our law school contract class, and we always heard that consideration does not have to be much to support a binding contract, and that a peppercorn will do. I'm sure we all remember that. But in the non-compete context, courts take a closer look at the adequacy of the consideration because an interest other than the party's right to contract is at play. The other paramount interest in the non-compete context is an employee's right to work. So consideration can take various forms, including, of course, more compensation, but it also can include new job responsibilities and job titles, new benefits, whether they be fringe benefits or so forth. Consideration also can include access to confidential information, access to existing clients, specialized training, or consideration can also be a change from at-will status to contract employee status. While the additional consideration does not have to be of tremendous value, it must provide a real benefit that the employer was not otherwise, that the employee was not otherwise entitled to receive. Therefore, the consideration must at least be an appreciable benefit to the employee. For existing employees signing non-compete agreements after employment commences, the Tennessee Supreme Court has held that continued at-will employment may provide adequate consideration for a non-compete agreement in certain circumstances. And a lot of jurisdictions hold that continued employment can serve as adequate consideration. And in determining whether continued employment under an at-will employment situation is sufficient consideration, courts consider the length of employment after execution of the agreement, along with the circumstances under which the employee leaves. So, of course, an at-will employee can be discharged for any reason or no reason at all, but a discharge which is arbitrary, capricious, or in bad faith will have a bearing on whether a court will enforce a non-compete covenant. In Central Adjustment Bureau versus Ingram, the Tennessee Supreme Court held that while the promise of continued employment is not sufficient consideration, actual continued employment is adequate consideration to support a non-compete agreement. So consequently, an employer could not enforce a non-compete agreement in Tennessee if the employee is terminated a day after he executes the agreement. Under Tennessee, unlike Tennessee, some state statutes like Washington and Massachusetts require that an agreement entered into after the commencement of employment be supported by fair and reasonable consideration independent of the continuation of employment. All right, now I want to focus on restrictive covenants in stock grants and equity award agreements. So this can serve as another form of consideration. It can be stock or it can be an equity award. And employers may include restrictive covenants in deferred compensation or equity award plans. Equity grants can include stock options, restricted stock units, and performance shares. Stock grant agreements can contain non-compete provisions that, one, cause the forfeiture of unvested grants, or two, claw back vested grants and proceeds, or three, restrain an employee from being employed by a competitor, which is the typical non-compete. Courts are, as you can imagine, courts are more likely to enforce a restrictive covenant, especially a non-compete, if the remedy for breach is merely the loss of compensation. So when the covenant gives the employee a choice of, one, working for the competitor and forfeiting the equity or grants, or keeping the compensation but not competing, most courts will enforce the provision. This is where the employee choice doctrine that I discussed earlier is implicated again. In this context, employees have argued that consideration is lacking in these agreements where the employer can retrieve or claw back the compensation. But courts have rejected that argument and found that the consideration of a stock award is not diminished or made illusory by the company's right to terminate the employee at any time for any reason after making the award, which would cause the employee to forfeit the award. In jurisdictions where continued employment of existing employees serves as adequate consideration, courts find that the stock award held actual value, despite the fact that it was subject to forfeiture under certain circumstances. Another point to remember is that just because one award agreement does not impose restrictive covenants does not mean that the next one will. Therefore, it is never too late for an employer or company to begin imposing restrictive covenants through its stock award agreements. Unlike the traditional restrictive covenant agreements that we've been discussing, which flatly prohibit former employees from accepting certain employment opportunities, these clawback provisions, again, give employees a choice between either retaining the benefit or engaging in the restricted competitive activity. Some courts adopting the employee choice doctrine have held that because these provisions offer employees the choice to compete, they don't even operate as a restraint on trade, and therefore they're enforceable if valid under basic contract law principles. So this means that as long as the employee's termination is voluntary, these courts enforce these clawback provisions without regard to reasonableness. New York, North Carolina, Virginia, Pennsylvania, Texas, Alabama, among some other jurisdictions, have found that these clawback provisions are enforceable under this reasoning. And an example of the theory that a restraint on trade argument can be completely defeated by giving the employee a forfeiture choice comes from an Alabama case. So there is an Alabama statute that declares that every contract by which anyone is restrained from exercising a lawful profession is void. But despite the strength and seeming clarity of the statute, Alabama courts have concluded that forfeiture for competition provisions do not fall within that statute's purview. Courts that recognize the employee choice doctrine, however, will apply the doctrine only if the employer demonstrates a continued willingness to employ the employee at the time of resignation. And forfeiture for competition provisions are not often drafted with the same considerations and limitations in mind as traditional non-competes. Thus, to the extent that the court finds the forfeiture provision unreasonable for whatever reason, it may not be able or willing to salvage the provision by modifying or striking the overbroad restriction and enforcing the reasonable remainder, like it might do in some jurisdictions if they adopt the blue pencil rule for non-compete agreements. The last point I want to raise on this issue is the method of offer and acceptance for non-compete provisions in such stock award agreements. In today's age of technology, many non-competes in stock award agreements are presented to employees online, and courts have enforced this method of offer and acceptance. All right, I will turn this over to David to talk about best practices.
Thanks, Terrence. I'm going to cover first considerations an employer should weigh with incoming and parting employees. And then next, I'll review particular provisions that an employer should consider including in a non-compete agreement, such as a choice of law provision, a forum selection clause, a separate requirement that the employee provide advance notice of departure, another requirement that the employee provide disclosure of the restrictions to their prospective employer, and a liquidated damages provision. The hiring employer must first determine whether a candidate is already under restricted covenant obligations, especially if the candidate is an executive or other employee coming from a competitor in a field where it would be likely that the candidate would have obtained confidential or proprietary information, such as finance or sales information. The prospective employer should get a copy of the agreement, obviously, and review the restrictions to determine the reasonableness, scope, and enforceability of the covenant. If the hiring employer can feasibly restrict the candidate's job duties, the employer should do so to minimize the risk of a tortious interference with business relations suit brought by the previous employer. If the new employer has a good relationship with the previous employer, the competing companies in many instances can resolve non-compete issues amicably without litigation, and they can agree to short-term compromises that address the concerns quickly and with little expense. So for example, if the non-compete restricts the employee from working for a competitor at all, the two companies could limit the work to a particular territory. Of course, whenever there are two competing companies that enter into an agreement, this raises antitrust concerns, so any agreement would need to be reviewed very carefully to avoid that violation. Now, for incoming employees, the employer must determine what information the employee will have access to, what is the nature of the work, and will a competitor be able to gain an unfair advantage if it obtains the information from the employee after the employee leaves. The key here, I think, is determining whether the information that needs to be protected is truly proprietary and worth keeping confidential. Also, the employer is the employer willing to take the time and incur the expense to litigate enforcement of the non-compete in the event the employee leaves and attempts to work for a competitor? If not, the employer could face a selective enforcement or waiver defense that Terrence touched on earlier in litigating similar non-competes against other former employees. And as we noted also, the employer must ensure sufficient consideration is given to support the agreement. In the case of a departing employee who has a non-compete agreement, the employer should have a sense of whether that employee is leaving on bad terms or whether there is a real threat of the employee potentially providing information to a competitor or soliciting existing employees or customers in violation of an existing non-solicitation agreement. As due diligence, the employer should conduct a formal exit interview and walk through the employee's obligations to comply with the non-compete. And if the other provisions that I mentioned earlier are present, the non-disparagement, non-disclosure, and non-solicitation agreements. And the employer should review with the departing employee his or her duty to disclose the restricted covenants to their prospective employer. Also, the departing employee should be reminded of the liquidated damages provision, and the company at that time, or even before conducting the exit interview, should cut off all access to computers and phones that the departing employee has. Now, with respect to particular provisions, the employer should include in a non-compete, first, a choice of law provision. A choice of law provision should be included in the overall employment agreement that would apply to enforcement of any provision in the agreement, including the non-compete. This is key because enforcement of any of the included restrictive covenants, as Terrence covered, is governed by state law, and state law can vary considerably depending on the state's public policy, legislation, and existing case law. The chosen law must have a significant relationship to the parties. Tennessee will honor a choice of law provision if the chosen state law bears a reasonable relation to the transaction and does not violate the forum state's public policy. So, for example, in a non-compete enforcement action, a Tennessee court would likely not uphold a California choice of law provision because California has a strict public policy prohibiting the enforcement of non-competes as impermissible restraints on trade. A forum selection clause should be enforced by a Tennessee court unless the employee can show that enforcement would be unjust or the clause is invalid due to some type of fraud or overreaching by the employer. Courts narrowly construe what is unreasonable or unjust, and in doing so, consider the following factors, including which state law governs the contract, the residence of the parties and witnesses, the place of execution or performance of the contract, any public policy considerations, and the availabilities of remedies in the selected forum, as well as any inconvenience or injustice concerns. A few other points worth mentioning are that some courts in states with a fundamental or strong public policy against restraints on trade have rejected forum selection clauses designed to circumvent that state's public policy, so California being an example. The argument of, quote, preventing forum shopping, end quote, has been rejected as a basis to void a forum selection clause. Also, courts will not enforce or otherwise reasonable forum selection clause if the parties do not have minimum contacts with the forum state. Also, disparity in bargaining power absent bad faith is not enough to avoid a forum selection clause. And since the court must determine whether enforcement of the forum selection clause would be unjust, it's recommended that language should be included in the forum selection clause that the parties agree that it is not unduly burdensome. Now, with respect to an employee's notification to the current employer, within a short period of time, 5 days is suggested, of the employee's separation or acceptance of a new position, the departing employee must notify his current employer of the new position if this provision is included in the agreement. This gives the employer time to assess the situation, review the covenant, determine whether the employee possesses confidential or proprietary information. The employer can also review the employee's computer files at that time and make a decision as to whether it should take immediate action to file a declaratory relief suit or request a temporary restraining order to stop the employee from going to the competitor. Of course, the departing employee may ignore the notification requirement, so a liquidated damages provision should be connected to this requirement also. The employer should also include or consider including an obligation in the agreement that the departing employee will disclose and provide a copy of the non-compete agreement to his prospective employer before accepting employment. This, of course, puts the prospective employer on notice of the restriction, which may prevent the prospective employer from hiring the person, or the prospective employer may reach out to the existing employer to work out an agreement to avoid litigation. The employee should be held to the obligation to produce a copy of the non-compete to the prospective employer for a 12-month period after leaving. The provision would also authorize the current employer to provide a copy of the non-compete to a company that hires the departing employee. Now let's talk about litigation and enforcement of non-competes. I think the first question is, should the current employer send a warning letter to the prospective employer explaining that the employee has a non-compete and that it will enforce it? I think the answer to that is it really depends on the circumstances. For example, the employer may go ahead and do this instead of immediately filing an action for a temporary restraining order, but it could be risky depending on the significance of the confidential or proprietary information possessed by the employee. If there is admissible evidence of a violation of the non-compete and a significant risk of immediate harm to the company, then I think the employer should immediately file for a temporary restraining order. If the employer sends a letter instead in that situation, it only puts the employee and new employer on notice, and they may file a declaratory relief action in the forum of their choosing first. So, but in circumstances where the harm is not as significant and admissible evidence of a violation is missing, the employer there may send a letter, and if it is ignored, can attach the letter to its eventual court filing. I think the judge will want to know if the employer tried to resolve the matter before filing the action, so attaching the letter would help in that respect. Sending a letter may resolve the situation, which of course will avoid substantial cost in litigating the case. The employer may also send a cease and desist letter to the employee that does not copy the new employer, as this reduces the likelihood of a tortious interference counterclaim if a lawsuit is brought. As I pointed out, if evidence is strong that the employee is violating the non-compete, the employer should file for a TRO. And I think the benefits in requesting an immediate TRO are that, number one, the employer controls where the lawsuit is litigated. Even if a forum selection clause is included in the agreement, the plaintiff, of course, could ignore it and file on a more favorable forum, hoping to get it voided. The TRO obviously stops the conduct that may harm the business. And then by filing a TRO, the employer sends a very strong message which can catch the employee off guard and have a deterrent effect. It also requires the employee to preserve all evidence at that point. And as another practice pointer, the employer at that point should get its evidence together quickly by obtaining information from the employee's computer and other business systems. The cons of seeking a TRO are that if the employer does not have admissible evidence in hand to support an irreparable harm claim, then the TRO may be denied, which can really stain the remainder of the case. On the flip side, the employee may file first seeking a declaratory judgment that the non-compete is unenforceable. The employee would file first to control the litigation, including the forum and applicable law. But of course, for the employee to do this, there must be a case in controversy, meaning that if there is no future job prospect in the industry for the employee, and so no present intent or ability to compete, then the employee may not have standing to bring the action. Now, with respect to selective enforcement, again, we touched on this earlier. The employer should enforce the covenant not to compete against all employees who have signed a similar agreement and who work in the same field or work group. Otherwise, when the employer does seek to enforce the agreement, the employee may successfully argue that the covenant is not necessary to protect a legitimate business interest, as evidenced by the company only enforcing against select employees in the same field. The judge will likely inquire about consistent enforcement. However, if the employer can show the selective enforcement was based on credible business reasons, some courts have found that the agreement is not invalid on those grounds. Courts have also reduced the duration of covenants based on the employer's enforcement of lesser durations as to other comparable former employees, and the employer's offer of a lesser duration upon the employee's announcement of departure. Now, last, employer liability for tortious interference with business relations. If the employer's action to enforce a non-compete is unsuccessful and the court determines the covenant was unreasonable, employees have been successful in bringing tortious interference claims. The claim applies to cases where an employer has cost the former employee a job, obviously, by unsuccessfully enforcing the covenant, or harmed the employee's job search in some other tangible way. These claims are dangerous for the employer and can expose the employer to substantial damages for loss of income and emotional distress. I'm going to turn it over to Terrence for the next section.
The last topic that we wanted to address was the government trends to limit covenants not to compete, non-compete agreements really are under attack from various governmental entities. And there has been a lot of state, federal, and agency governmental activity relating to non-compete agreements over the past several years. And I will, in these last 10 minutes or so, I will discuss the top developments that occurred in like 2018 to date. So first, let's start with Congress. And David mentioned this earlier in the webinar, but it's important to note again that non-compete agreements are governed by state law, not federal statute, not a federal statute or federal law. And thus, non-compete agreements, the enforceability of these agreements vary by jurisdiction. However, there was another attempt in Congress to ban non-compete agreements nationwide. Senator Chris Murphy, a Democrat from Connecticut, and Todd Young, a Republican from Indiana, introduced bipartisan legislation in 2019 entitled the Workforce Mobility Act, which I will from here on out refer to as WMA. The WMA seeks to ban non-compete agreements outside of the sale of a business or the dissolution of a partnership. And not only would the WMA abolish non-compete agreements nationwide outside of the extremely narrow exceptions I just mentioned, it would also provide the Department of Labor and the Federal Trade Commission with broad enforcement power. So if the WMA was enacted, the legislation would empower the FTC and DOL to enforce the ban through fines on employers who either fail to notify employees that non-compete agreements are illegal or who require employees to sign covenants not to compete. Additionally, the WMA establishes it would establish, if enacted, a private right of action for all employees allegedly aggrieved by a violation of the WMA. The WMA contains, as it is currently drafted, a carve-out for parties to enter into an agreement to protect trade secrets. So as currently drafted, the WMA does not abrogate the scope of protection provided by the Defend Trade Secrets Act. And presently, there are no generally applicable federal restrictions on non-compete agreements. And enacting such a law would have to pass constitutional muster. But we expect to see continued activity at the federal legislative level to attempt to ban or limit, at least, the use of non-compete agreements. Now, shifting to state legislation regarding non-compete agreements, there's also been a great deal of activity on the state level to restrict these agreements. And time will not permit me to cover all the state's legislation because we only have an hour, but I will discuss some of the most common state legislation limiting non-compete agreements, including one common provision in some state legislation is requiring an employer to provide a terminated employee with a signed written copy of his non-compete agreement within a certain number of days of his termination from the employer. And failure to do so would render the agreement unenforceable. So for instance, in Oregon has a statute that says that the employer must provide the non-compete agreement to the employee within 30 days of separation. Another common provision in certain state legislation is that many state laws eliminate non-compete agreements for low-wage employees. So for example, in Washington state, non-competes are prohibited for employees earning less than $100,000 a year. Maine, New Hampshire, Massachusetts, Maryland, and Illinois are all some of the other states that have also passed legislation limiting non-compete agreements on low-wage employees. And this has been a focal point, not just on the state level, but on the federal level and on the agency level, which I will discuss in a minute. And as I discussed earlier, some state statutes require independent consideration for non-compete agreements entered into after employment, separate from continued employment. And some states require that non-compete agreements be limited to 12 months, with a few exceptions. But as we discussed earlier, 1 year typically is considered reasonable, and some states require that the non-compete be limited to 1 year. Also, as I discussed earlier, some state statutes expressly invalidate any non-compete agreement with an employee who was laid off or fired without cause. And several state statutes require the garden leave clause that I mentioned earlier in non-compete agreements unless there is other mutually agreed upon consideration. Another common statutory provision requires that employers provide employees with a notice period before executing a non-compete agreement. This is designed to allow employees time to review the agreement and negotiate its terms. As David referred to earlier, California, as you may expect, is an outlier. California has long been hostile to non-compete agreements. And in California, they are essentially per se unenforceable, except in regard to trade secrets, partnership dissolution, or a shareholder selling his interest. So what I want all the viewers to take from this is, definitely check the state law that you are, litigating in, because many state statutes heavily regulate the enforceability of non-compete agreements. Now let's talk about some other government trends, starting with the state attorneys general. In addition to the state legislation that I just summarized, a group of 18 attorneys general filed comments with the Federal Trade Commission in July of last year in advance of a series of hearings centered on changes to antitrust and consumer protection enforcement in the 21st century. And the letter identifies 4 major areas where recent antitrust activity involving labor issues have occurred. And one of those areas was non-compete agreements between employers and employees. Many of those same AGs sent another letter to the chairman of the Federal Trade Commission in November of last year, urging it to use its rulemaking authority to bring an end to what it classified as the abusive use of non-compete clauses in employment contracts. And the efforts by these AGs appear to be a reflection of their enforcement priorities rather than a genuine expectation that the FTC will actually grant their request. The letters also highlight the alleged use and enforcement of non-competes against low-wage employees. And this is what I was talking about earlier, that the protection of low-wage employees has become a main focus, not only in state, legislative activity, but also with these governmental agencies. And while there may be isolated incidents of employers seeking to enforce non-competes against these low-wage hourly employees, employers more often seek to enforce such agreements against senior or executive level employees who have knowledge of the employer's valuable trade secrets, or customer-facing salespeople who may use confidential information to take customers to their new employer. So in their letter, the AGs offered alternatives to non-compete agreements, and according to the AGs, the arguments in support of non-compete clauses are, quote, unpersuasive, end quote. They recount that employers argue that non-compete clauses allow employers to recoup their investment in job training, methods of business, and other intangibles. The AGs submit that instead of non-competes, employers can use negotiated non-disclosure agreements that David discussed earlier, or trade secret and intellectual property law to protect their investment. The AGs believe that employers can also provide term employment contracts with workers, offering workers job security in exchange for workers committing to a job for a fixed period. And the AGs also suggest, I feel cavalierly, that employers can also offer regular raises and promotions to retain workers. The overall theme, however, of the AG's letter is that non-compete clauses inhibit innovation and may actually drive consumer cost up by suppressing competition from rival businesses. Let's shift gears now to the federal government agencies. So within the last 14 or so months, the U.S. Department of Justice and the Federal Trade Commission held public workshops to examine the effect of non-compete clauses in employment contracts on the labor market. And the purpose of the FTC workshops was to examine whether there is a sufficient legal basis and empirical economic support to promulgate a commission rule that would restrict the use of non-compete clauses in employment contracts. So scrutiny of non-compete provisions will remain an FTC priority in this year, the remainder of this year, of course, especially in the wake of changes to the state labor laws that protect these low-wage workers. After a general presentation on these clauses and the presentation on the regulatory landscape, the FTC's workshop commenced by reflecting on how non-competes allegedly chill labor mobility, stifle wage growth, worsen income parity and business enthusiasm, cause anti-competitive harm, increase the chances of a monopsony, which is a market situation where there's only one buyer. Assuming there is evidence to convince the FTC to act, the ideas offered included: one, banning non-compete agreements altogether for low-wage workers, creating a rebuttable presumption in court that non-competes are illegal; three, limiting non-competes to those with access to a company's trade secrets; four, minimizing the duration and geographic scope of such provisions; five, requiring garden leave as consideration for the enforcement of these agreements; and six, voiding non-competes unless the employer has disseminated notice of the covenants at appropriate times. And so you may notice that the ideas offered at the workshop are very similar to statutory provisions that many states have enacted, limiting non-compete agreements. The FTC's deadline to submit public comments has expired. So that, I think it expired in May, if I remember correctly. That concludes our 1 hour webinar on the enforceability of restrictive covenants. Thank you for accessing this webinar addressing this important issue. We tried to analyze various legal aspects on the enforceability of restrictive covenants within a 1 hour time frame. We could have had a 1 week webinar on this. There are so many important issues. But we do hope that you found this webinar informative and enlightening. Thank you.